charities. Okay, sorry, I just got this meeting is rather loud, this meeting is recorded. As well as organisations such as charities, indeed, such as that led by Claire, who'll be speaking later, who were also affected by the unlawful actions of the Home Office. So the sort of question we were looking at this evening is what next for refugees, and how do we resist this act, and what does that act mean in practice? So I'm just going to briefly rattle through some of the key provisions of the Act. I'm pretty sure most people on this call know them fairly well, but I don't think it hurts to go over them again. And just in case there's anyone on this call who isn't familiar with them, it's really important to know what's going on. I'll then go on to speak a little bit about the Rwanda challenge, and then go on to speak about what all of this might mean for a fictionalized individual. Before I do that, I just want to stress that although the Act is a sort of fundamental change in legal practice, it wasn't without warning, it wasn't unprecedented. We've seen decades prior of really regressive legislation in the asylum and immigration sphere, legislation aimed at narrowing the definition of who's deserving of protection, in particular focusing on restricting the benefits that asylum seekers can access, limiting or removing certain appeal rights, criminalising asylum seekers and those who help them, and increasingly intrusive forms of control, in particular the use of the detention estate, and things like tagging. So although the Nationality and Borders Act is a really big change, I think it's important to set it in context, which is decades prior under governments of various different shades, bringing in a really unwelcoming, should we say, legislation. So just to go into some of the key provisions, I mean, one is this differential treatment clause. So from, the 28th of June onwards, when most of the key provisions come into force, we're going to have two groups of refugees in this country. Bearing in mind, this is about refugees, so people who've been acknowledged as deserving of international protection. These people whose claims have been processed and they're successful. You'll have one group who came here via safe and legal routes, and they'll get what people up to now got. So, 5 years, route to settlement, access to benefits. There's going to be this other group, presumably much larger, of people who will be criminalised on arrival. So that's a very significant change. They will only get 30 months of leave, and they'll have to reapply every 30 months. So they won't get that sort of mental reprieve of knowing you have 5 years. They are going to have limited access to public funds and things like refugee family reunion, and they're not going to have an automatic right to settle. So what these people did was they didn't come via the safe and legal routes, they came via so-called irregular routes, they came in indirectly. I'm sure everyone on this call knows, but I'm going to labour the point because it's so frustrating. There are extremely few safe and legal routes. There's one for some Afghans, there's the Ukrainian one, there's one for some people in Hong Kong, there used to be a Syrian one, but these are really limited, and even the ones that there are quite dysfunctional and hard to get yourself through. So for the vast majority of people now who wish to seek sanctuary in this country, there is no way for them to do so without committing an offence and without getting this much smaller package of rights. There is something called the UK resettlement scheme, but you can't apply for that. You have to sort of sit in a UN camp and wait to be chosen. And in any case, the numbers subject to that are very small. There's kind of lots of fuss made about the UK resettlement scheme on the Home Office website, but it's not something you can apply for, as I said. So for most certainly of our clients going forwards, there's no safe and legal routes. That's a really fundamental change because they're only going to get this very limited package of benefits and be criminalised. The second clause I just want to rattle through is the inadmissibility regime. So this is where the UK is not going to consider your asylum claim. I hope the background noise isn't too bad. The UK will declare your asylum claim inadmissible, and what that means is you're not going to be processed. It's just not going to get into the system, what will happen is you will be declared inadmissible and sent elsewhere. And this is going to happen to people who have a connection to a safe third country. You could have a connection to a safe third country in 5 different ways, but they include you passed through a safe third country and applied for asylum there, or you passed through a safe third country perhaps, and it's felt that you should have applied for asylum there. You could have. So a few points, the Refugee Convention does not require you to apply for asylum in the first safe third country. That wouldn't make any sense, because then everyone would apply in the countries that border refugee producing places. I mean, that is mostly what happens anyway. I note that we are an island, so this is obviously a very convenient focus for the law to have. And also, more importantly, refugees should have some agency and element of choice in where they end up going. If you actually spend any time talking to people, they have very compelling reasons to want to come to the UK. Now, the inadmissibility regime is one under which the Rwanda policy is being implemented. It's not currently being implemented under the Nationality and Borders Act. It's being implemented under a different set of laws, under the immigration rules. I will get onto that when I go on to speak about the challenge. But they're in practice the same. There are also concerns about offshore processing of claims, although TBC what that will look like. So that's why you'll be sent abroad whilst your claim is being processed and then sent back here if you're successful. Things like asylum reception centres, so sending people off to remote ex-RAF bases to sit whilst their claim is decided on, which is, really bad for integration. People don't have access to the specialist services they need often. And it's just very isolating for people, and it puts them in, presumably it's going to put them in control of companies like Serco and G4S rather than living in their community with access, especially to the legal and medical services that they might need. Introducing new methods for assessing age-disputed children, which the scientists on the panel can speak more to, but I understand are not at all sort of supported by the scientific community. Making it harder for you to be recognised as a victim of trafficking, make it easier to exclude people from the Refugee Convention who have criminal records. It just kind of goes on and on. But those are the clauses I really wanted to pick out of the Nationality and Borders Act. So a piece of revision, I'm sure, for most people on the call, but an important one nevertheless. Worth also noting the Judicial Review in Courts Bill is removing a particular kind of judicial review that you use in an immigration context. I won't go into the gory details, it's called the CART JR, but a really effective safeguard for people who had unlawful decisions in the first tier tribunal, and that's simply being removed, except in certain cases. And of course, the Police Crime and Sentencing Bill, which is making it harder for everyone to protest about these changes. So that's a quick rattle through the legislation. As mentioned, I've been working on the Rwanda challenge, in which Care for Calais is one of our clients, and they're on the call. We have also another NGO called Detention Action, who are one of our clients, and PCSU, which is a union that represents lots of Home Office officials, and we're also representing a number of individuals who received removal directions to Rwanda. As I said, this was initially being implemented under the immigration rules, and it will be put on a statutory footing by the Nationality and Borders Act. So what happens to these people is they're people who arrived this year. They arrived via a dangerous route. So basically, it's aimed at the people arriving on small boats across the channel, and they're people who passed through safe, quote unquote, safe third countries. So primarily, these are people who've come through France and add some other European countries usually. And what's happening is they arrive, they are detained on arrival, they are given a very brief screening interview, which elicits very little information from them. And these are also people who've just arrived and often very traumatized, very vulnerable people, might not be in a position to be disclosing a lot at that point. They then are going into the detention estate, they're receiving a letter which says they are being considered for removal to Rwanda. They have 7 days to reply to that letter. If they're lucky, the letter is being translated to them orally. They may not have a lawyer at this point, so they have 7 days to respond to a letter in a different language about a process they don't understand whilst they're in detention. So lots of their focus will just be on almost certainly survival, because detention is a terrible, terrible place to be. If the Home Office has its way and that the policy is to be implemented, what happens at the end of that is you may receive removal directions if you fail to persuade the Home Office your claim should not be declared inadmissible, and then you will be removed. So that's the policy, and as I'm sure you're all aware, the stated aim is to deter people from making these dangerous crossings. I'm going to talk in very general terms about the challenge because it's ongoing litigation, but it's all, well, we have a hearing at some point next month. That will be a substantive hearing where arguments will be put forward about the lawfulness of the policy. We have very, very grave concerns on a number of different grounds about the lawfulness of this policy, including, well, for example, the apparent determination by the Home Office that Rwanda is in general a safe third country for people to send to absent particular circumstances. We simply don't think there is the evidence to support that conclusion in their assessment, and we think there is evidence to the contrary. Very concerned about potential Article 3 mistreatment, so that's the prohibition against inhuman and degrading treatment, punishment, and or torture. And in particular focusing on concerns around the asylum system in Rwanda. So the idea that it's nascent, to use a term that was used in evidence in the hearing, that it's not set up to deal with the kind of very complex asylum claims that we might be sending their way. It generally deals with, asylum seekers from neighbouring countries. Concerns about bias towards Middle Eastern applicants. Of course, concerns about bias by LGBTQ applicants. The list goes on, but those are some of the concerns. And the UNHCR has intervened and has echoed and magnified that evidential basis. They've expressed as well very, very grave concerns about the safety of people who may be sent there. Another ground of challenge is relating to Article 31 of the Refugee Convention. You're not meant to penalise people for how they enter. You're not meant to penalise people for their illegal entry, and it appears to us on a legal analysis that that's what this does. That's what this policy does. So those are the grounds of challenge, and we'll have those ventilated in court amongst others next month. You will have seen in the press last week that the first flight to take off with the initial set of people bound for Rwanda did not take off. That was the subject of challenge on the grounds of sort of interim relief, which is where you basically say, until we've decided on the lawfulness of this policy, we were arguing, let's not send anyone. And basically what the court then has to do is say, if the policy is eventually found to be lawful, but we grant the injunction, what harm does that cause? If the policy is eventually found to be unlawful and we don't grant the injunction, what harm does that cause? And there's a balancing exercise. The High Court didn't agree with us. We were arguing that the harm to people sent, even in an interim period, was so great that it should be that no flight should take off until the main hearing. But then each of the individuals eventually were not removed through various different. They all had sort of slightly different routes to get off that plane. So that was just about interim relief. No courts have made any findings on the lawfulness of the policy to this date. So it's really, we've got a very, very, very brief a very brief pause. I think, have I horribly gone over my time already? No, I've got a minute. Okay. So that's on that challenge. I'm very happy to answer more questions where I can. As I said, kind of only speak about it in relatively general terms. I'm just going to rattle through now what this might look like for an individual. So this is completely fictionalized, but I think it's a realistic account of where we end up with our current policy legislative framework. So let's say you have someone who leaves Sudan because of the ongoing conflict there, and they travel to the UK. Maybe the UK is where they're aiming for because they speak some English, It's an ex-colony, so perhaps they know more about it. Perhaps they have a brother here, I don't know. And they've traveled through, let's say they've traveled through Libya. This happens with a lot of Sudanese asylum seekers, and there they've been a victim of human trafficking, so a very vulnerable person. On arrival in the UK, they're going to be criminalised. They have committed a criminal offence. They're going to be detained on arrival. That's not new detention. Detention has been a part of our immigration landscape for a long time. Remains a complete stain on it. If they claim to be to be a minor, they'll be subject to these new sort of age assessment methods where they'll have bits of their body measured and their saliva checked. They may be given this letter, and I explained the process to you, of 7 days. Let's say, for the sake of argument, they managed to challenge their removal to Rwanda. They may remain in detention whilst any overall decision is made on their asylum claim. Under the new Act, they might only have 5 days to appeal any initial refusal of that claim. They are released. It looks like they're going to be released on tag. They might be sent to one of these remote asylum reception centres. And there they will wait, and they will probably wait for years for the final determination on their claim, because the process is so slow and inefficient. They'll be subject to the whole gamut of the hostile environment whilst they wait. They will find that certain appeal rights will have been removed or seriously curtailed. And then at the end of this, perhaps they are recognised as a refugee. And even at that point, they will only have a sort of really limited pool of limited benefits. So that's how we're treating people who end up getting recognised as refugees. Not even talking about all the other people. Lots of other people in this country who don't end up getting recognised as refugees or are here seeking other forms of leave. So yeah, it's a kind of bleak picture, and I'm sorry because I don't want to paint a bleak picture, but this is a really seismic change in practice from a legal perspective. And we'll be in court next month with this Rwanda challenge, and we'll wait to see the outcome of that. But there are so many other aspects of this new regime which are really, really worrying and really troubling. And we can see that the definition of who's deserving of protection is being narrowed, appeal rights are being restricted, access to justice is getting worse. The benefits you do receive if you're recognised as a refugee are worse, and we're criminalising seeking asylum. So in terms of sort of how to help, I think staying from a legal perspective, staying informed is really important, knowing what is actually happening, because there's a lot of misinformation about what the law is and what the policies are and what they mean, being clear about the facts. From my perspective as a lawyer, the law isn't about what's moral or not, or what I think is right or not. It's about what's lawful or unlawful, and you have to absolutely focus on that as a lawyer. It's the job really of other amazing people who are on this call to make those arguments. We might, as a lawyer, you can win battles, but you can't win the war about overall, the overall context of how we view migrants in this country. One thing I would just say is that detention befriending groups, people who work with people in detention, are so important and so helpful. So if anyone can, take time to do that, it's just been an absolute, godsend, especially in this challenge. One of Claire's colleagues, Hannah, in particular, has just been amazing at helping people in detention who have been affected by the Rwanda policy. And without people like that, it's very hard to do the legal work, because it's hard to get access to these people and to get documents to them, get documents from them, take instructions, find out that they exist in the first place. So I would really give a particular shout out to the people who work with those in detention, because I think otherwise people end up so isolated. I think that's my time, so I'm going to stop there. There are some questions. I don't know if we're going to
there are some questions.
Yeah.
I'm not sure if we have time for them just now. I would suggest that maybe what we can do is put some of the answers in the chat, so it's not well designed for that. But yeah, maybe we can do that, and we can move on. I thank you very much for a really interesting talk. I think it's quite a useful I think it's really useful. I think there are quite a few things that are unclear to people. The idea of what does inadmissibility mean. A lot of this is quite opaque and confusing. And I can see from some of the questions in the chat as well that there's just a lack of clarity about who's affected and how they'll be affected and where people are being picked up from, and how all of that works. And I just wanted to pick up as well. You mentioned the police bill and the attack on the right to protest, and I think there's quite a few pieces that are coming together at the same time right now, in terms of different pieces of legislation that create a really, to borrow a phrase, hostile environment for those who are trying to support refugees and migrants. And I think also, just to highlight, there's a lot in the news at the moment about how um, you know, judges are not elected, and so this is not democratic. And I think it's really important for all of us to push back on the idea that somehow the judicial system is not part of democratic processes. Because it is really a false, it is as false as Boris Johnson complaining today that people who object to Rwanda, people being sent to Rwanda, are being prejudiced against Rwanda. I thought that was quite right. I will move on to Dr. Liz Clark, who is clinical advisor at Medical Justice. Liz is a GP and has been carrying out clinical assessments and writing medical legal reports for asylum seekers for over 10 years with Medical Justice and Freedom from Torture, and has worked as a medical manager with MSF, working with survivors of violence, sexual violence and torture in Greece, Lebanon and Egypt. Thank you, Liz.
Hello, thank you, Claire. Thank you, everyone. I'm very happy to be here and join the other speakers. I'm going to talk a little bit to start with about medical justice, if people don't know about medical justice. So we're a small independent charity. We were established in 2005. We're the only charity in the UK with a specific clinical remit to assess people in immigration detention. So we've been going into immigration detention centres for the last 17 years or so. Our clinicians visit detainees in immigration removal centres, or do this remotely by phone or by Skype. We do a comprehensive clinical assessment and then write a detailed medical legal report which documents evidence of that detainee's experience of ill treatment. So that's both their physical scars and their psychological scars. We document their current physical and mental health and the impact of being detained. And most detainees that we help are later released. So we identify histories of torture, sexual violence, trafficking, other persecution because of sexuality, religion, ethnicity in their country of origin, but also on their journey to the UK, and sometimes further exploitation in the UK. Our clinicians diagnose severe depression, PTSD, complex PTSD, psychosis, suicidality, and also sometimes lack of mental capacity for that person to give instructions or provide evidence in relation to their asylum claim. So we're unable to do that for all the referrals that we receive, and so we have to prioritize, and we prioritize those where it appears that their mental health or their physical health has deteriorated significantly, if they appear to have significant vulnerabilities, or where removal is imminent. So, that applies to the Rwandan cases. Medical justice also campaigns for lasting change. Ultimately, we campaign for the end of immigration detention. And we do that through policy work, strategic litigation, raising public and parliamentary awareness. I'll talk a little bit now about immigration detention. There's a wealth of evidence that immigration detention causes harm, and that's particularly on the detainee's mental health, and that harm increases the longer somebody is in detention. Medical justice has contributed to this evidence and has long-standing concerns about the quality of healthcare that is provided in immigration detention. We've published multiple reports, and we've provided evidence to the Home Office and to statutory bodies such as the HM Inspector and Inspector of Prisons. So the Home Office claims that healthcare in detention is equivalent to the NHS, but we have identified many areas of substandard care, which include brief assessments by clinicians, poor clinical evaluation, lack of review of previous medical records, which show that that person has deteriorated over time. There's lack of identification of histories of trauma and related symptoms. There's lack of use of interpreting services. For those with more complex mental health presentations, there's lack of detailed psychiatric assessments. So there can be, quite vulnerable people, and they're easily overlooked because they sort of present as vague, and they're uncooperative, their unusual behaviors are not explored, and they're not followed up if they miss appointments. There's lack of provision of individual mental health support or counselling in some immigration removal centres. If a detainee is identified as having a history of trauma, they're given a trauma pack, which is written in English, and they're meant to use that to self-manage their symptoms. We know that secondary care appointments are missed. Difficult behaviours are treated punitively by use of force or segregation rather than being considered an indicator of underlying poorly managed mental health conditions. There's a lack of understanding of the impact of prolonged and indefinite detention. There's lack of staff training, and the sort of culture of indifference and disbelief. Medical justice has particular concerns about the ineffectiveness of safeguards, including the so-called sort of screening mechanisms when a person enters immigration detention, and these fail to sort of proactively identify patients at risk of harm who should be released. Medical justice has done that. The latest report, which is called Harmed Not Heard, highlights all these problems. So even when risks are identified by healthcare, such as suicidality, there's an inadequate communication of those risks to the Home Office, and where information is reported to the Home Office, this doesn't generally lead to release of that person. There's a sort of normalization of the toxic environment where detainees witness violence, they witness distress of others, they see other people being removed, there's self-harming or suicide attempts. PTSD symptoms in particular are likely to be aggravated by detention, and we see that in many of our clients. So they get triggering reminders to their original trauma, and that's particularly the case if they have a history of being tortured, or they have a history of being deprived of their liberty because of imprisonment, or trafficking, or enforced domestic servitude. So all the symptoms of PTSD, sort of debilitating fear, insomnia, nightmares, agitation, hyperarousal, all of these symptoms are likely to worsen, and that's what we see in many of our clients that we visit. I'll talk a little bit about asylum seekers in the community, and then this impact of the Rwandan policy. We already know for asylum seekers in the community that they're often isolated, they have little social support, they live in substandard accommodation, with an asylum allowance that is little more than £5 a day. They have little control over their lives. They're unable to work. They can be exposed to anti-refugee discourse. They can have multiple physical symptoms, including chronic headaches or chronic musculoskeletal pain. And they have their mental health symptoms of depression, anxiety, PTSD, which are very difficult to treat if they continue to have a fear that they will be detained in immigration detention and a fear of being returned to their country of origin. So we know that asylum processes can take years, and if somebody is a failed asylum seeker, they can be destitute because they have no recourse to public funds, and they're vulnerable to exploitation. So asylum seekers already face a lot of uncertainty and lack of hope. And then now we have the adverse impact of the Rwandan policy. So, that's likely to have a very significant impact on asylum seekers, and it risks provoking self-harm and suicide. We're aware that it is creating a huge amount of anxiety and distress, and our clients have been contacting us, feeling hopeless, frightened, being unable to sleep, self-harming, writing a suicide note. They are very fearful of what will happen, and they don't believe that they will be protected in Rwanda. I think it's very interesting that the government thinks that being sent to Rwanda is going to be enough of a deterrent that people won't cross the channel, but also think that it's going to be a very nice place for people to go to. So it seems a little bit two-way thoughts about that. So we know that previous clients of ours who have been released from immigration detention and are in the community, they've been contacting us about their fears about this. And this included, a previous client who is from Rwanda and has been granted leave to remain. And he's been in contact to express his fear that now that Rwanda is deemed a safe country, the government might choose now to send him back. So I'll just say a little bit about our involvement so far in the people that have got these notices of intent to send them to Rwanda. So at the time of the planned flight on the 14th of June, we had 26 clients in immigration detention who had these notices of intent. From the information that we're aware of at the moment, who is chosen for removal from a group arriving to the UK in a small boat, it seems to be very random. Some people who arrive in the same boat, one person is detained and other people are not. And it doesn't seem to be that there is any definite criteria for that at the moment. So we've seen nationalities who include Iraqi, Iranian, Sudanese, Egyptian, and Eritrean. And many of these countries are countries that have a very high asylum grant rate in the UK. Some are torture, survivors of torture or are trafficking victims. As Charlotte said before, if you're given a notice of intent, you have 7 days to respond to say why you should not be removed to Rwanda. So one of the detainees who contacted us, they did so with regard to their asthma medication. And this person was not aware that he had been given a notice of intent 5 days previously. And we told him that because after he consented to send his the information he had been given by the Home Office, and we were, saw that and said, well, you were aware of this, and he wasn't aware of that. So 11 of our clients were issued with the removal directions for the Rwandan flight, and 3 were amongst the, I think, 7 or 8 who were taken to the airbase, ready to leave in the evening of the 14th of June. So we're very thankful to all the people involved that they were taken off the plane and returned to immigration detention. This is, of course, it's sort of an evolving situation. We're working with our legal partners and are guided by clients' legal representatives who can give us instructions for writing a medical legal report to help identify specific clinical issues which can support that person in their human rights claim, such as physical injuries, mental health vulnerabilities, and maybe sexual orientation, which would affect their mental health is sent to Rwanda. And we may be asked to include an assessment of fitness to fly, for example, whether any behavior arising from underlying poor mental health conditions could interfere with the safe conduct of flight. I'll just say very briefly a little bit about other Home Office policies, although I think Charlotte has mentioned some of these. So there is this, the Home Office is rolling out this GPS tagging. It has been for anyone released on immigration bail who is subject to deportation. It's causing a lot of distress to our clients who report feeling criminalized. They say that the stigma of wearing a tag, and actually if you see the tags, I mean, they're quite large, they're quite obvious, they're not, you can't hide them very easily. Stigma is making them reluctant to go out, and the tags, they need charging daily, and it's exacerbating their mental health symptoms. We know that this is now being expanded to asylum seekers who are not subject to deportation following criminal convictions. And I think, as Charlotte said, yes, it will be expanded to people who were meant to be removed to Rwanda. We know that asylum seekers continue to be housed at Napier Barracks, and there are 9 new accommodation centres that are proposed. The first of these is at Linton on Ouse, which is, I think Charlotte said again, an RAF base in North Yorkshire. And as she said, you know, these very isolated areas. It's a sort of it's at vast expense, and asylum seekers remain in limbo. They're not able to integrate and start to rebuild their lives in local communities. So it does nothing well, their mental health and their physical health is very likely to deteriorate. And Charlotte said again that the Nationality and Borders Act will limit the rights of those, even those whose claims are successful, and people will have to make repeated applications to renew their entitlement to remain, and they may not be permitted to have family members join them. So again, these factors, the lack of family support and the continued uncertainty and lack of safety that results from that is likely to lead to ongoing depression, anxiety, PTSD symptoms. So yeah, this is a significant problem too. Just to say a bit about Rwanda, I have seen it written that there are very limited mental health services in Rwanda. There's something about there are 12 psychiatrists in the whole of Rwanda. There are 2 psychiatric hospitals. The Rwandan people themselves already have high mental health needs based, as a result of the genocide in 1994. So, yeah, how people are going to receive the care that they need if they do go to Rwanda, yeah, we don't know. And that, yeah, that's it then.
Thank you very much, Liz. It's really interesting. I think I saw a couple of questions in the chat, so if you want to take a skim through and maybe respond to those. I am going to gallop on because I want to make sure we have time for all of our speakers. So I'll move now to Claire Mosley, who's the founder and head of Care for Calais, which is supporting migrants and asylum seekers in Napier Barracks and asylum accommodation. Care for Calais, of course, as Charlotte mentioned, was one of the organisations that challenged in court the government's proposals to forcibly remove people to Rwanda. So I will hand over to you, Claire.
Okay, thank you. So on the 18th of May was the first time I spoke to one of the people in detention who had a Rwanda notice. The government were taking them straight off the boats to detention and giving them the notices. They said that was so they didn't abscond from the hotels, but I do wonder if it's so that they weren't arriving in the country, not knowing anybody, being in detention and not being able to contact anybody either. What we immediately started doing was giving out leaflets right across Calais and Dunkirk and Brussels, telling them that if they arrived and got taken straight to detention, how they could contact us and then get a lawyer. And over the next 4 weeks, we did actually speak to all 130 of the people who were given the notices of intent. But I do wonder if we hadn't have done that, if some of them would have ended up without lawyers, which is a very frightening thought, and whether that was the original intention. Of those 130 people, 55% of them were married and 20% of them had children. So being told that these are all single men isn't actually true. They're just men who don't happen to be with their families at that point in time. Not that it would make it okay if they were single men, because single men are still humans and still should not be treated that way. But it does prove that's false. 7 of them were under 18 years of age. 43 of them had family in the UK. 2 of them actually had a wife in the UK. One in particular had a son in the UK that he was incredibly distressed about leaving. He hadn't seen his son for a few months, and when he was told at the end that he was one of the people who was on the plane, he thought he was never going to see his son again. It was absolutely awful. So as well as affecting all those individuals, it affected all their families. We spoke to many of their families. We cried with many of their families, and with them, it was horrific. One thing to note about people that I think is really important is that 33% of them were Sudanese. That can't be right, because we know that 4% of the people who cross the channel on small boats are Sudanese. So 33% of the people who were given notices should not have been Sudanese. And 16% of the people who were given notices crossed in lorries, and they were all Sudanese. So it really feels to me like Sudanese people are being targeted. And I don't know why, but I'm really sure that's wrong. They were saying to us, one of the most I heard was, why am I in prison in the UK when I haven't committed a crime? I thought you didn't get put in prison in the UK if you hadn't committed a crime. I never thought the UK would send us to Rwanda. I thought the UK was a good place that treated you fairly. On my journey, the thing that gave me hope was hope in the UK. That's now been destroyed. If the UK isn't a good place, are there any good places left on earth? A lot of them said to me, I will kill myself if I get sent to Rwanda. We really heard that a lot. For people who'd come from Africa, being sent back to Rwanda represented being sent back to the place where all the original bad things had happened to them. The things they were fleeing were in Africa, and they felt like they were being sent back there. For people from the Middle East, they couldn't understand why they were being sent to a continent that they had no connection to whatsoever. They were just bewildered by it. And all of the people that we spoke to were terrified. They were all absolutely horrified at the thought of being deported. Liz spoke really eloquently before about how traumatic it is for refugees to be in detention. And they were all traumatised by it, but they were also traumatised by the thought of being sent to Rwanda. At one point, we had a 5-day hunger strike. We had over 20 people on hunger strike. And we were speaking to them, trying to get them to stop all the time. Oops. The way we got them to stop in the end, we had calls with them, and we were saying to them, this isn't going to help. The Home Office actually sent them letters and said, if you don't stop hunger striking, we will send you to Rwanda quicker, which was compassionate of them. We had a call with them in the end, and I spoke to them and I said to them, I promise you, you're not going to Rwanda. I probably 70% believed in it because I believed in the UK that we wouldn't do it. But I also felt that I had to, because it wasn't achieving anything and it was better if they stopped. So that's what I told them, for better or worse. when we went to court in June, as Charlotte explained, that wasn't about deciding whether or not the policy was lawful. That was about deciding whether or not we could deport people before it had been decided whether or not the policy was lawful. And I was quite shocked that the court said, yes, we could. And when we went to the appeal court and they said, we can deport these people, what they said was, we can deport them because if it's later found out that the policy is unlawful, we can always bring them back. And that just completely ignores the reality, which is these people who are victims of the worst things that happen in the world, of wars and conflict and persecution and torture and trauma. So they're already victims who have visible and invisible scars, would be so traumatized by being sent to Rwanda. That's not something that we could take back. And what if they did kill themselves when they got there? We couldn't take that back. And what about the harm done to their families? We couldn't take that back. So they might have found a way to verbalise a rationalisation for it. But to me, it's so fundamentally wrong that I was really deeply horrified and shocked that a British court came to that finding. A very senior British court actually made that ruling. For me, that was very deeply shocking and troubling. And it reminded me of in 2014 when they stopped the rescue missions in the Mediterranean, and the rationale was we have to let people drown in order to save lives because it will deter them from getting in the boats. And even though hundreds, probably thousands of people around the world, sensible, normal, otherwise human people said that rationale, I would never ever be able to believe it because I know how utterly wrong it was. And that's what it felt to me. They might have found a way to say it, but it can't be right. And that is really upsetting to me that a very senior British court said that, because I don't believe it's right. And that makes me think, how have we got to a position where this can happen in the UK? Because just like those refugees who believed in the UK, I do too, or I did. And I think it's because we've had years of the British government basically repeating messages like, if they cross a safe country, they're not genuine refugees. If they come through Calais, they are illegal. And saying they're illegal is a really terrible, dangerous rhetoric, because it basically says they have done something wrong, and they have not. They are victims. All they have done is be born in the wrong place. They are victims of the worst things in the world. But repeating that message again and again and again, that they are illegal, makes people think they've done something wrong. It's victim blaming. And the fact that it is our government that's repeating that message has to be noted, because it's not the tabloid newspapers anymore. It's not the Daily Mail. It's our elected officials who are repeating what is essentially propaganda. It's a false story for political reasons. And it's got us to a place where our court made that ruling. And I really find that troubling and distressing. And we had to tell them, we had to phone them up and phone up their families and tell them, which was just awful. But we had to do it, and we had to do it quickly as well, because I didn't want them to hear it in the press. So when the volunteers were saying to me, we don't want to make those phone calls, I was saying, I'm so sorry, but you have to phone them now and you have to tell them. But then amazingly, the European Court stepped in and they said, no, this can't happen because there is a risk of really serious harm, which to me was obvious from the start, and I hope to you as well. So they have stepped in, so that's good. But now we have a question over human rights. Now our government wants to do something about our human rights. The Director of Liberty wrote a letter, I think it was today, saying that they want to rip up the Human Rights Bill. And to me personally, what that means is when we talk to the refugees, particularly from Iran, we talk, people leave Iran because they don't have human rights there. They leave Iran and they come to the UK because they believe it's a good place that respects people's human rights. And that is so valuable. And we're actually considering throwing it away, which is just devastating, because I see the results every day of how very, very valuable that is. I see people having to leave their homes and everything they love because they don't have human rights. And yet we've actually got it, and our country is considering throwing it away. It's just devastating. And the other thing I just really briefly wanted to mention is, because we're talking about other aspects of the new Nationality and Borders Act, is the temporary protection. Because for the last 2 years, we work in asylum accommodation across the UK. And all the problems that we have seen, I believe, come down to one fundamental problem, which is the delays in processing claims. So what we see in the newspapers are problems with asylum accommodation, problems with food, problems with them not being able to work or study or everything else. But the root of all those problems is the delays in processing claims, because they come here to get asylum. They risk their lives, they spend all their money, they do everything to get asylum. That's what they need. And when there are massive delays, they become more and more afraid they're not going to get it. They start to believe that there's something wrong with their claim, that they've heard about somebody else who arrived with them who's got asylum, and therefore it's their problem. And they get really frightened. And the mental health impacts of that, the fear and the uncertainty, grow and grow and grow until even the ones who are the strongest and the smartest and the most resilient break under that. And it manifests itself in them complaining about the accommodation or the food or whatever it is. But that's not really the problem. They lived in Calais, they can cope with accommodation and food problems. It's the delay and the uncertainty and the fear. And they wouldn't need the right to work if their claims were getting processed quickly, because they would be working. And everything else wouldn't matter. That is the biggest problem. And temporary protection is going to expand that forever. And to me, it means that we're not giving them asylum, because asylum is safety. And if we're not giving them safety, we're not giving them asylum. And as was pointed out earlier, the number of people who are not going to be on this is immaterial. So basically it's all of them. So pretty much we're not giving asylum to anyone. So from the 28th of June, the UK is stopping giving asylum to pretty much everyone. And that's just heartbreaking and awful. But that's what it means to me in practical terms. So this is a Take Action group. We are obviously going back to court. We have a massive battle to fight, and we're going to fight it as hard as we possibly can with every tool that we have. We are supporting the new people who come into detention. We are running out of lawyers. Supporting 130 people in detention was incredibly hard. We have to phone them all the time because they're frightened. We have to keep phoning them. We have to update them, tell them what's going on. We have to help them with their papers. We have to help them with the stupid fax machines that they are still using in detention centres. It's really resource heavy. We need help. We're going to have to campaign as much as we possibly can, because although this is a legal battle, it's not just a legal battle, it's a battle for public opinion. So we need as much support as we can, because public opinion is the one thing that our government does listen to. So it's really important that we fight that battle with every tool that we have. So that's what we need help with. We need resource, we need campaigning, we need support. Thank you for letting me be here with you.
Thank you as always, Claire. It's always really good to hear from you, and I know how many of your volunteers are working directly with people in accommodation in the detention centres. So really important to have that that voice from working directly with people affected. And in that vein, I'd like to turn to our last speaker, Nadine Tanasi, who is a survivor from Survivors Speak Out, which is a national network of people who have survived torture who use their expert voices to raise awareness about the impact of torture and advocate for policy changes. So I will hand over to you so we have as much time from you as possible, Nadine.
Thank you, Clay, and thank you so much for having me. And from a lived experience voices, I would like to tell you how much I'm grateful that we have people in this country who are fighting, for the vulnerable. Like Clay mentioned, I'm a member of the Survivors Speak Out Network. I'm a refugee from the DRC, Democratic Republic of Congo, and I've been living in this country for more than 20 years. And after I finished my therapy, I wanted to do something. I wanted to join a group of people who are going to raise their voices to speak for people who could not speak for themselves. Basically, we're talking here about people who can't be in this room, who are in detention, who are made feel that they have no right to be given protection. And I'm also a member of One Strong Voice, which is the first UK coalition network of people with lived experience. Basically, we are campaigning for a better asylum system. And really, I have to say that the hostile environment, like I said, I've been here for more than 20 years. It's not something new in this country. And in my personal experience, after waiting 3 years for my interview at the Home Office, I decided to chase the Home Office via MPs, my MP then, to request for an interview so that my case would be dealt with and I could go on with my life. I really hated to be left in the limbo. And I can tell you, even after those efforts, and to cut a long story short about that, because there's so many things that happened, it took the Home Office 7 years before I was recognized as a refugee and given my status. And I used to tell my story of how I had to wait 7 years until I discovered that there are people in this country. There are actually people in my network, both networks, Arab Speaker Network, and the One Strong Voice, that are still waiting after 10 years, 15, 20, and even more. And in fact, we have a member in our network, in the Survivor Speak Out network, who, when she came in this country, she had a son was 3 years old. And with the current policies, they still have not managed to get a secure status in this country. So his status is linked to his parent. And what that means is when he finished high school, he wasn't able to get access to higher education to go to university. And I'm talking about a bright boy who only wanted to just to go to university. And the boy doesn't understand why, you know, after finishing university, secondary school, he can't go to university. He can't explain to his friend why he's not able to go for further education. And like I said, this boy was in this country from the age of 2 years old. Having said that, the environment that refugee and asylum seekers that are facing now is unprecedented. You know, I mean, I can say it was difficult for me, but what I see now really breaks my heart. It's even more difficult. You know, we have people in our network also who have lived in the barrack, and they have described the condition very difficult, distressing, and in many cases have suffered mental health. We also have people who have received judicial review, decision from the Home Office, and the Home Office, they have received judicial review, basically the court saying they have the right to be in this country. And the Home Office is still refusing to write a letter to send the status. And, you know, if you come from a country where really the rule of law, all these great things that we hear about Britain and developed country, you wonder really, where is the separation of power? How can the judge rule that you're allowed to stay, you've proven everything, but the Home Office is still refusing to implement the ruling? And really to touch on the new Borders Act, you know, Charlotte, you said a lot of things. I was, you know, just briefly to say on the differential, can never say that properly, differential treatment. We did a lot of campaign on that. You know, when it was still the bill, we were campaigning on the clause 11. I can't understand. You know, I was going to, you know, explain, but you know, you as a lawyer, I would not repeat that. So you've covered that. Just say from my own experience that being a refugee, you know, has nothing to do with the way you come. You know, I don't like the fact that people use a safe and legal route. You know, because what is a safe and legal route? When I'm in danger, you know, do I have time to pack my bag, to get the papers and decide which country? I think this narrative from the government is really, you know, trying to say in a way that, you know, get time and get prepared and choose the country you come. And we know that, you know, when you are fleeing, you hardly even have time to pack a picture, you know, of your memory that you will have to keep in, you know, in the country that you're going to. Let alone to say that, you know, people have the choice to choose. I mean, refugees don't have the luxury to choose where they're going. When I was coming, I mean, I came to Britain, I wasn't choosing to come, you know, to come to this country. If I had a choice, I would have chosen to go to Belgium because I've already had my family there. My mother was already in Belgium. And, you know, this is the country where I came, and I'm happy to be here, you know. But we don't have a choice. We don't have the luxury in haste, in a hurry, fleeing danger to make the decision that I'll be going to Britain. And I find it really unfair, from the government to try and portray that, because I know they know, that people don't do that, they can't do it. And to touch on that, really, the fact that it's going to be the type 1 and type 2 refugees. If people really have, could choose about using like a resettlement scheme, the truth is these things are not in every country. They are not everywhere. I can tell you they were not in my country when I was fleeing. And if they are, the process can sometimes take many years. The process can be very dangerous. And in some cases, going to seek that help might even further put your life in danger. And with the protection that will be given for the class 2 type refugee, I know that the limited protection of the amount which you have to reapply also means that you will not automatically have the right to apply for family reunion. And really, we are a country that really uphold and preserve and defend human rights. Why are we saying that refugees will have to be separated from the family? Because they did not come so-called illegally, I don't believe there are safe and legal routes. I think that if you are in danger and you're trying to preserve your life, you will do whatever it takes to get to safety, because life is special. Life is worth fighting for. And the hostile environment does not create a welcoming feeling. And in order to be welcome, refugee needs to be integrated in the British society. The refugee need a chance to work, to get education, and not to be sent to some institutionalized accommodation or detained. I don't understand why the government would choose to put vulnerable people who are not criminal in institutionalized accommodation. When I arrived in this country, I live in a hostel. Then I can tell you already, I escaped that because I got ill. And it was already really a bad thing. And I can tell you there was a lot of things going on. There was so much poverty. The food wasn't good. There was so many people getting, I was one of them suffering from mental health, but the condition was so bad that there was actually sexual exploitation going on in the hostel. And I'm talking about hostel, where we still had maybe the opportunity to go to the park. And what I'm hearing from people, who, for example, the person who live in the barrack, it just means that, you're sending a message in this country that refugees are not worth or deserving to be part of this society. And I can tell you, having been living here for more than 20 years, we are human beings. And then we want to be able to be in this society, contribute and give. And then again, when you say that, you say, yeah, there we go. You are an economic migrant. You're looking for an opportunity, to get your life better. And I have to say that the example in Ukraine or Afghanistan have shown us that when you're fleeing, you don't have really the time, to say that. I mean, we're seeing people fleeing Ukraine, the war. They get to where they get to. They will get to to the country that will welcome them, that will be possibly open for them. We cannot ask people who are fleeing danger to be making that choice. On the differential treatment, there's also been the differential treatment in the sense that we also saw the reaction, I mean, I'm so sorry for what is going on in Ukraine, but it's been really hard noticing the difference in reaction. You will know that refugees do suffer, and I think it's been said already, but demonized, another word I can say, we've been demonized and portrayed in a certain way. We never survived the media, highlight of who refugees are. But we saw the reaction when the war started in Ukraine. The reaction is the government needs to do something. Well, the home, even scheme, we created, people are paid to welcome refugees. So it does show you that, this is not about really that this country maybe does not want refugee, but it's about which type of refugee that this country wants to welcome. You know, the treatment of non-white refugees is so obviously different. And Ukrainians who are part of Europe, obviously, some people don't even saying, you know, don't call them refugee, they are not. I mean, if somebody's fleeing war, fleeing persecution, who are they? We're even refusing to use the same word as refugee. And I really say it does show you that you cannot tell somebody who is fleeing danger, you know, choose to go to Britain, choose. I mean, in fact, we've been seeing it, people who have family members in the UK wants to be reconnected, and quite rightly so. Why not? You know, to join a family member maybe in a country in Europe. This hostile environment has been causing a lot of pain. And I'm telling you, and I think it's been said a lot, people are living in fear. People are worrying about tomorrow. And also really, as a result, because of the bad campaign, there are more and more racism, you know, attitude towards refugee in this country, you know, because if all we hear, people that can hear the same narrative that refugee are bad, they're criminal, they're this and they're that, how do you expect people to react? You know, we have to change those narratives and really show that, you know, it's not what everything that you hear in the newspaper or the government want us to believe is not true. And I want to say on the Rwanda scheme, the UK is a signatory to the Geneva Convention, and I'm not speaking as a lawyer. And processing asylum claim for people who arrive in this country is not a country duty to do. Refugees who arrive in this country should be dealt with by the UK government. The UK should not be, you know, I mean, to be honest, if one thing I'm going to say, there is, you know, I like I think it was you, Charlotte, that was saying, you know, it's not just about the morality of it, it's also about the law. Is this country still going to be complying to the obligation that, you know, it is signatory to? And I don't want to go into the debate of whether Rwanda is a safe country or not, because I think that it would contribute in diverting the conversation. You know, people are living in fear, and this government wants people to be left in limbo. And I can tell you, before arriving here, we've already have long journeys, and the policy, the hostile environment is adding more miles to our journey. I can't exclude myself from this because, you know, I'm a British citizen now, but always be a refugee at the end of the day. And I'm reminded of the hostile policy that, you know what, no matter what, people are not going to forget. And refugees need rehabilitation. You know, it's a journey, they need healing. And the policy that we have now is not helping people to do that. And I don't believe that anyone who is sent to Rwanda will really want to stay there. This policy is very dangerous, and we only give smugglers more opportunity to exploit those who try to escape. The scheme is discriminatory because only a certain type of refugee will be sent there, the non-white refugees. The Home Office, I think it's been said, claimed that they will only send men, and this narrative is the same, again, to use to demonize, you know, male refugees, saying that male asylum seekers are dangerous, they're economic migrants, they're criminal. And let me tell you, those men are people's brothers. They are someone's father. You said that. They are someone's husband. Because I was granted refugee asylum status in this country, with the help of the Red Cross, I was reunited with my brother, and he managed to get refugee status in this country because of me. And then another message is that the government is trying to say, you know, they are not deserving to be in this country. And they would rather pay a lot of money to the Rwanda government to see if they will take them, because there isn't any guarantee that the Rwanda government, you know, they will still have to go through a process. And, you know, maybe the government is considering this as enough, you know, processing somehow, process, but it's a one-way ticket. People are going to be sent away and never to be back. Where is the human right? And before I finish, I'll just tell you, I am the UK champion government for sexual violence. And I work closely with the Foreign Office to advise on policy when it comes to sexual violence in conflict country. On the other hand, we have a government that is promoting welfare of survivors, That policy needs to be correct to protect the vulnerable, but we do have policy here, the Home Affairs, who potentially will be treating the same people who come and seek protection, we treat them badly. So there is a contradiction somewhere. The UK is a leader. The UK needs to lead by example. We can't be telling people where conflict happen, where sexual violence happen, that this is how you should treat survival. This is how kind you should be. This is how the government should implement policy. When potentially when the same people who come in this country, we're going to treat them differently. And there was a time, people admire the freedom this country could offer. But now, I don't know. This is the UK that I knew 20 years ago, the country that welcomed me. And I know many people in this country still believe that the UK should provide sanctuary to refugees, but we have to fight to put an end to the hostile environment and to say to the government that it's, that often claim that they're delivering the people will, to tell them that no harm should be done in your name. Do not allow anybody to use your name, that they're doing this because this is the will of the British people. So my ask for you this evening would be, please, support campaigns that, Médecins Sans Frontières is doing, any organization. Yes, let's support financially wherever we can. Let's write to our MPs and let's put pressure, if on the airline that will potentially be used to carry refugees, and let's use the social media to really advocate and let people know what is happening. Thank you.
Thank you so much, Nadine. And I think that really ends on the note that we are all here for tonight, which is to really encourage people to take action and to be very to be engaged and to stand up. And I think we're talking about refugee rights, and we've already made a nod earlier to the link with the right to protest, and I think we've seen how now the whole issue of human rights is also being drawn in, and everything is being called into question. And so it really is that old quote of, first they came for one group and then they came, but I wasn't from that group, and so I didn't stand up. It's all of our rights that are at stake, and we really need to fight. Are there any, we do have just a few minutes left, about 5 or so minutes left. Are there any questions that anyone would like to ask? Okay. I did not think we would end a couple of minutes early. I'm very impressed. I'd really like to thank everyone for joining. I know it's been quite a jam-packed week, and a lot of people have been working really hard on all of these issues and are quite exhausted. It's been also, for anyone who's following them, just an emotionally exhausting time. And so thank you everyone for joining, and particularly to our speakers for speaking and for the really important work that you do. I guess we will all continue to try and work together on these issues. And yeah, I thank you all for all of your hard work. So with that, I will bring it to a close. Thank you and have a lovely evening.
Thanks so much for organising, Claire.